It is now the defense's turn to present their case in the penalty phase trial for the Parkland school shooter.
And they began with opening statements earlier today. Local 10 News reporter Christina Vasquez has been in that courtroom. She's joining us live from Fort Lauderdale. What did they have to say this morning, Christina?
And you may remember, so this really kicks off the start of the defense case presentation. They deferred the chance to do their opening statement, which they just did right now. And think of it as a way, an opening statement, to cue up the issues. Now, in the case for the defense in this penalty phase, it also gives them an opportunity to flip the script a bit. The lead defense attorney here leans right in off the top with where we just ended. The very powerful and harrowing case presentation. You remember prosecutors presented to jurors some really gripping, gut-wrenching testimony from medical examiners, from victim impact statements. You might remember they did that jury visit to the 1200 building of Marjorie Stoneman Douglas, which was preserved as a crime scene. She starts right there. The jurors have been away for 2 weeks. In some respects, they've had some time, but she leans in right off the top with this expectation of, I saw what you heard, what you saw, she even says, may haunt you for years to come. And then she gives the overall outlook of what she wants them to think about as they move forward through the case presentation. Again, a penalty phase. Guilt has already been established here. He's already pled guilty to shooting and killing 17 Marjorie Stoneman staff and students on Valentine's Day 2018. So she says, what you're not going to hear from us, and this is something she also had said during jury selection, you're not going to hear from us a defense. This is literally indefensible. We are not going to give you any reason that says, oh, this is why he did it. Instead, we are going to present with you evidence we want you to consider, evidence that they feel one of these individual jurors might compel them not to choose death as the punishment. Again, the jury in this penalty phase, they have the singular task of being fair and open-minded when it comes to being open to weighing all of the evidence and then making this recommendation on the punishment. Should it be life in prison without parole, or should it be death? And when it comes to what the defense needs to do in terms of its case presentation, according to legal analysts, and remember, in order to get death, that has to be unanimous, right? That the prosecutor has not only had to prove what are called aggravating factors by Florida state statute beyond a reasonable doubt, so their burden of proof was higher. All the jurors have to unanimously decide one of those exists before they can even consider death. But then they also have to be unanimous in choosing death. That means that if just one juror of that 12-member jury decides that life is the appropriate punishment, then they would get life. And so you see in the opening statement, the lead defense attorney really hitting on this concept of this is an individual decision. This is not a collective decision when you get down to making this recommendation. And then she begins to tell a story. And in that story begins to introduce and already begin to help them understand and connect the dots. Here are the people you're going to hear from, and here's why we want you to be opening to considering the following. So in the defense term in the penalty phase, it's called mitigating circumstances. Sounds really big. Essentially think of mitigating circumstances as the pieces of information or evidence that they want the juries to be open to and listen to that might compel them, again, not to choose death. So we know it's going to be something about his childhood, right? And about his background. And within the opening statement, she really weaves two central characters. Think of it as the tale of two moms. A biological mother, she says, that poisoned him from the womb by using drugs and alcohol while she was pregnant with Nicholas Cruz. And then the adoptive mother, which throughout the entire opening statement, she weaves in how it would appear from the defense view, the adopted mother was inept at really managing the developmental delays, intellectual delays, emotional, social delays that came from being poisoned by the biological mother. Let's listen in together.
What do we know about Brenda's pregnancy? We know that it was very stressful and chaotic. The majority of her pregnancy, she was homeless and living on the streets. We know that she was using drugs. We know that she was smoking cigarettes. We know that she was drinking booze. Proper nutrition and proper prenatal care were not a priority for Brenda. She was an addict. And because Nicholas was bombarded with all of those things, he was poisoned in the womb. And because of that, his brain was irretrievably broken.
And what's interesting is twice she actually references a poet, and I'm going to read it to you because she made a point to stress to the jurors. And now that you've heard what she had to say, you can get a sense of what it was like to be a juror there this morning. The quote she gave them is, "The beginning often holds the clue to everything that follows." She also reminded them that jury selection, they told this court that they could be fair and impartial when it comes to sentencing, that they could carefully weigh and consider all the evidence, and she stressed them to do just that. It is anticipated that this afternoon we'll already be getting into some of the first defense witnesses. Reporting live for you, I'm Christina Vasquez, Local 10 News.